Hello students, in today's session let's learn about Indian Contract Act 1872. Everybody would have heard about business law, commercial law or mercantile law. They all are synonymous terms. Business law denotes the aggregate body of legal rules connected with trade, industry and commerce. It includes law relating to contracts, sale of goods, negotiable instruments, insurance, partnership, companies, consumer protection, etc. Now let's have a look on law of contract. What is law of contract? So, law of contract is the most important part of the mercantile law. The law of contract is the foundation upon which the superstructure of modern business is built. It is not only the merchant or trader, but every person who lives in an organized society consciously or unconsciously enters into contracts from sunrise to sunset. When a person buys a machinery or hires a taxi or takes a loan from bank, he enters into contract. It is common in business transaction that promises are made at one time and performance is followed later. Such contracts create legal relations, giving rise to certain rights and obligations. The object of law of contract is to ensure that the rights and obligations created by contract are honored. History. Now coming on to the history of Indian Contract Act 1872. The law relating to contracts in India is contained in Indian Contract Act 1872. It extends to the whole of India except the state of Jammu and Kashmir. It is largely based on English common law, which is mainly made up of judicial precedents. Now coming on to the definition of Indian Contract Act. Indian Contract Act 1872 section 2H defines the term contract as agreements legally enforceable by law. So the contract is made up of agreement and the legal obligation created by it. Now we'll start with the essential elements of a valid contract. All agreements are not contracts. However, only those agreements which is enforceable at law is a contract. So the first essential element of a contract is an offer and an acceptance. In order to create a valid contract, there must be a lawful offer by one party and a lawful acceptance by another party. So an agreement is made up of offer and acceptance. Second essential element of a valid contract is intention to create legal relationship. The intention between the contracting parties is to create legal relations. In case there is no such intention on the part of the parties, there is no contract. Agreements of social or domestic nature do not complete legal relations. Third, lawful consideration. Consideration is an essential element in a contract. Consideration has been defined in various ways. According to Blackstone, consideration is recompense given by the parties contracting to another. In other words of Pollock, consideration is the price for which the promise of another is bought. Fourth point, capacity of parties. The parties to an agreement must be competent to contract. If either of the parties does not have the capacity to contract, the contract is not valid. Accordingly, the following persons are incompetent to contract. First is minor, second is persons of unsound mind, and third, persons disqualified by law to which they are subject. Fifth essential point of a valid contract is free consent. Consent means parties must have agreed upon the same thing in the same sense. According to section 14, consent is said to be free when it is not caused by 1. Coercion, undue influence, fraud, misrepresentation or a mistake. An agreement should be made by the free consent of the parties. Next important valid point is lawful object. The object of an agreement must be valid. Object has nothing to do with consideration. It means a purpose or design of the contract. Thus, when one hires a house for use as a gambling house, the object of the contract is to run a gambling house. The object is said to be unlawful. If it is forbidden by law, it is of such nature that if permitted, it would defeat the provision of any law, it is fraudulent, or if it involves an injury to a person or his property of any other, or the court regards it immoral or opposed to the public policy. Next essential element of a valid contract is certainty of meaning. According to section 29, agreement the meaning of which is not certain or capable of being made certain are void. The terms of the contract must be precise and certain, that is, it should not be left vague. Next important point for a valid contract is impossibility of performance. If the act is impossible in itself, physically or legally, if cannot be enforced by law. For example, Mr. A agrees with Mr. B to pull out the stars from the sky. Such agreement is not enforceable. Next, not declared to be void. The agreement, though satisfying all the valid conditions, all the valid points of the contract, which has not been expressly declared void by any law in force in the country. Agreements mentioned in section 24 to section 30 of the Act have been expressly declared to be void. For example, agreements in restraint of trade, marriage, legal proceedings, etc. Next important element of a valid contract is legal formalities. An oral contract is perfectly valid contract, except in those cases where writing, registration, etc. is required by some statute. In India, writing is required in cases related to sale, mortgage, lease, gift of immovable property, negotiable instruments, memorandum and articles of association of the company, etc. Registration is required in cases of documents coming within the scope of section 17 of the Registration Act. Hope you have got a good insight on the Contract Act. Until we meet again, bye.